So, as I said, we are introducing ourselves to the model company law. As the academic regulations indicate for your LLB, the company law is taught in 2 semesters. So, semester one, semester two, but but that does not mean that we have two company law. Company law is just one. Just like many areas of the law, it's just one particular area. But for convenience of academic management, because we use what we call the semester system, the course is broken down as it well into two parts. So that part is taught in the first semester and the other part is taught in the second semester. So that is the rationale for having company law 1 and company law 2. It is not really the case that we have two company laws. So please, let's get that straight. Company law is just one. And that has a certain implication. The implication is that because it is one area of the law, things that we will learn and discuss in the first semester will certainly have relevance or some bearing on things that we learn and discuss in the second semester, and vice versa, because it is one and the same area of law. So let us keep that in mind. So, what is company law as a model? This model will seek to introduce you to fundamental principles of company law in terms of substantive law. I'm aware that as we make progress to the Ghana School of Law or the professional legal education segment, there is a course they call company law and practice, and that is supposed to let you get the requisite skills regarding how uh, the company law actually works in practice as it were. So that will be taught. But for now, our focus or our interest lies in knowing the substantive law. In other words, what are the norms? Please, let's observe this house keeping rule. Anytime you are in a Zoom or online meeting, your mic should be off. If you want to speak, you raise up your hand, and then the facilitator or the lecturer would allow you so that we don't have a messy class. Thank you. And talking about the substantive company law, we are largely talking about the principal legislation in this particular area of the law, that is Companies Act 2019, Act 992, which repealed and replaced the old principal legislation we learned company law under, which was the Companies Code and later Companies Act 1963 at 179. Of course, there are related legislation, Incorporated Private Partnership Act, Registration of Business Teams Act, Corporate Insolvency Restructuring Act, banking and other special deposit taking legislation, Borrowers and Lenders Act. All these legislation are important component of what constitutes company law. So therefore, as a course, it seeks to explore the historical development. In other words, uh, the things that we call company law, how have they evolved? And it will interest you to note that as we journey along, you will come to appreciate that the principles, the doctrines we have in various areas of company law were informed by certain happenings, certain developments. And in fact, if you look at even the bulk of general company law, you all know the famous South Sea bubble, that scandal in English corporate world, which actually paved the way for a whole commission to be set up to look into certain developments leading to the collapse of a company which had been patronized by the public putting their money into it. And then the government at the time being very embarrassed and say that no, what is wrong? We need to know. Is it the case that uh, those using the corporate vehicle, using the company to run their business, were they given excessive freedom without any significant regulation so that they were able to take advantage of unsuspecting members of the public that wanted a place to invest their idle funds, as it were? So all those things were done, and eventually a report was made and leading to adoption of the major legislation on on companies. So the point being made is that most of the things that we'll be learning came about as a result of certain historical happenings or developments. So we would also look at theoretical underpinnings. It's not enough to know that a company, upon being incorporated, for example, is a separate legal personality. It's not enough. We need to understand why that is the law. And I must say that company law is a subject which is not learned by only law students, only LLB students. It is also learned by non-law students, particularly those doing business. If you go to most of the business schools in the university, Presbyterian University and other universities around the country, if you go to their business school, you notice that they also learn company law. But the difference between you as an LLB student learning company law and a non-law student learning company law is that you are not just going to know the principles, you also be in a position to understand and appreciate the underlying rationale, the theoretical constructs which underpin the principles, which underpin the doctrines which you learn. And that is what sets you apart from others. So we also explore forms of business, association, incorporation, corporate personality, role of directors and officers, shareholders, corporate finance, meeting, takeovers, and corporate insolvency. So the course actually seeks to explore all these areas. So to put it simply, the course is interested in the very start, making decision which model, which vehicle are you going to use to organize or run your business? And the process of bringing that into being, how it is shepherded, how it is run, right up to its coming to an end, its dissolution, or its collapse, as the case may be. So all the things which take place along that trajectory are what we are interested in learning in company law. So therefore, the aim of the court is basically to equip you with both doctrinal knowledge and practical appreciation of company law in Ghana. So let us keep that in mind. So what are the learning outcomes? When we say learning outcomes, in other words, by this course, we're asking you to commit a certain amount of your time to learning company law, okay? Now, when you have gone through all that, you'll be directed and instructed to go through. And if you cooperate with you cooperate with the efforts being made by your lecturers or your instructors and teaching assistants, uh, you will notice that at a point in time, you should be able to ask yourself, what have I gained? Again, we as an institution, we as a university, we also owe society a responsibility. And what is that? At the end of your 3 years or 4 years, we are going to issue you with certificate and say that we can put our hand on our chest and say that you've gone through the requisite training, and we certify that you have attained the requisite knowledge or competencies as far as company law is concerned, among other things. So, we are making this statement to society. And how can we be sure that we are not deceiving society? And that is why certain outcomes or certain targets are actually set. And those are what we call like the learning outcomes. So if we are able to establish that we have met this, then we are confident that we can project you to society as you having actually learned company law. So what are they? By the end of this course, a successful student should be able to explain the nature, the scope, and source of company law in Ghana, distinguish between different forms of business organization and their legal implication, analyze the process of incorporation and the legal consequences of corporate personality. Should be able to evaluate the powers and duties of directors, managers, secretaries, and auditors. And you should be able to discuss shareholders' rights, remedies, and protection mechanism. And of course, you should also have the ability to explain company finance, shareholding, debentures, and charges. And a successful student should also be able to assess rules governing company meetings, resolutions, and decision making. Another learning outcome is that a successful student should be able to critically examine restructuring. When we say restructuring of a corporate entity, what is it? You should be able to examine it, the issue of winding up and insolvency under Act 1015. And again, a successful candidate should be able to apply statutory provision and case law to problem questions and real-world scenarios. And you notice that when it comes to law, legal norms are reflected in two main ways: through decisional law, what we call like the case law, like mainly like the common law aspects of, and then statutory law. So company law, for example, is a classic case as far as statutory law is concerned, because the bulk of the norms, the bulk of the law you'll be discussing and you'll be talking about are actually grounded in certain legislation or certain statutory provisions. And that is very important because you are going to read the rare text of the law. And in fact, when I am teaching, I've been teaching company law for many years. I've been teaching company law many years, I must say, even going back even to 2001, 2002, when I was teaching the ACCA students corporate law, and then 2005 when I started teaching company law in the law faculties up to date. So I used to teach a company law in a certain way that is according to the traditional magisterial approach, like just rattling, giving lectures, and then the students will just go and you go away. But over time, I have noted that students should not just be talked to about the law. Students should have the law explained to them, because in real life, when they become lawyers or when they become people working with the law, they're actually going to work with the rare text of the law. So if that is the case, why should I tell you stories about the law when we can look at the law itself, and then we will read and understand, and then we explain and then we illustrate. And if there has been any interpretation problems as reflected in case law from the courts, we look at that. So that way, we hone and sharpen our skills as far as uh, dealing with statutory law is concerned. And of course, it will also enable you to deploy it into real world scenarios. As you will notice, uh, company law is not esoteric. It's not an abstraction. It's not something that you cannot relate to. The things that we will be talking about are things which actually happen in the concrete world of business. So we'll be looking at the actual scenarios and illustrations. And some of you, especially for the introduction that we did, are even already working with company law in one way or the other already. And if nothing at all, some of you, including my humble self, we are shareholders of companies. So we deal with companies. So those are the things that we want you to be able to ask yourself if you have developed capacity for that at the end of the course, the learning outcomes. Now we want to take ourselves through the topics that we are going to be learning. So when we meet our next class, we are going to discuss introduction to company law. And by introduction to company law, we'll be asking ourselves, what is company law? What is its nature? What is its essence? What is the scope? In other words, what does it entail? What are the boundaries? Which matters cannot be characterized as company law? Then we also look at the historical development of company law in Ghana. And when we are discussing that, I always go back for obvious reason. You notice that our law is largely received law. Remember the Supreme Court Ordinance of 1876, which provided legitimacy for introduction of the English law in its various manifestations in our legal system. So therefore, the history of company law in Ghana is inextricably linked with the history of company law in the metropolitan legal system, that is in English company law. So we go there and we trace our roots from there up to our present situation of company law. And having done that, we will be looking at sources of company law. And source of company law is important. And in fact, when you are learning law, any area of the law that you are learning, one thing you must always ask yourself is that what are the sources of the legal norms? In other words, the rules which you are dealing with in that particular area of the law. Where are the rules derived from? And that is very important because in your legal system in the first year, and of course, thank God, I'm also a legal system person. So in your legal system, you learned about classification of law, okay, or divisions of law. And the purpose of learning and teaching classification or divisions of law was not just for some academic cosmetics, right? Just beautification. No, it was for a rare functional purpose so that we're able to know when we are dealing with matters of corporate law what forms part of corporate law, because there are certain crystallized way of looking at things which are proper for company law and may not uh, work for other areas of the law. And again, if somebody says that this is lawful under the law, and let's assume the person is speaking with reference to company law in Ghana, we will almost immediately be interested in asking or finding out this thing which is being asserted as forming part of our company law. Where can it be located? Can it be located in statutory company law, as in maybe Act 992, or the Corporate Insolvency Restructuring Act, or any of the legislation? Or can it be located in the case law? Case law as in decisions of the court based upon the legislation? Or is it a matter of a common law? If I say common law, that is those principles which have developed, right, from the early part of English company law, which are not necessarily based upon explicit provision of our current legislation. Or equity. So if what is being asserted cannot be found in our constitution, cannot be found in legislation, case law, common law, or equity, then we find it difficult to agree with the person that what he is asserting is really part of our company law corpus. After the introduction to company law class, our next class, for our purpose, our week 2, will be forms of business organization. Forms of business organization, we'll be looking at the various forms, and that is very important. And when we are learning it, we even go to a little bit of economics. We look at a bit of production theory that, assuming you are an entrepreneur, you have the factors of production, you want to marshal them to do business. What are your options? What vehicle are you going to use? What strategy, what means? Are you going to use partnership? Are you going to use what you call one-man business, sole proprietorship? Are you going to use the, uh, let's say, the incorporated company? Or are you going to use a cooperative? Why will you use this business organization and not that? And whatever you decide to use, what are the legal requirements for bringing it into existence and operationalizing it? So those are some of the matters that we will be discussing under week 2. And still there, we will look at the distinction between incorporated and unincorporated association. Incorporated and non-incorporated association, are they the same? And even for incorporated association, what they call the corporate soul and corporate aggregate, what is it? Our next class, week 3, will be discussion of incorporation and the theory of corporate personality. Incorporation, we will learn when we get there as a process by which we bring into existence the corporate entity, which we call the company or corporation. So we have to know like the processes, the procedure. Now, when you have gone through the processes and you have been certified as having attained the incorporated status, the law ascribe certain what we call privileges or incidents to you. In other words, certain consequences flow from an entity being satisfied as having been duly incorporated. And what are those consequences? What are those legal effects? We'll be exploring that. And we will look at a very important case, what we call the seminal case, the decision in Salomon and Solomon. And it is a case that I would like everybody to read like the full judgment even before we get there. To read the full judgment before we get there because it is a cornerstone decision or what they call like a landmark or cause célèbre as it may be or locus classicus as far as company law is concerned in a number of respects. Just as you are learning law of tort, we say that you must know the case of what? Somebody should fill in. Yes? That is the most locus classicus as far as tort is concerned.
Donoghue versus Stevenson.
Donoghue and Stevenson, yes. So once you are learning law of tort, you cannot say that you do not know Donoghue and what? And Stevenson. Or if you are doing contract, cases like, yes, yes. What are some of the landmark cases? Which is so common that if you say you've learned contract and you don't know it, you'll be a suspect. Hello?
NCST versus
NTAC versus NP.
Carbolic Snowball.
No, Carly and Kabbalah smoke ball. That is okay.
Yeah,
Carly and
yeah,
Kabbalah
yeah,
smoke ball, all right.
yeah, 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 yeah.
Hmm. Okay, good. Then we will also look at the doctrine of corporate veil. The fact that once the company has been incorporated, it will be seen on its own terms, in its own rights. It will be seen as a legal person, as a juristic person, and be treated more or less like a natural person, as it were. So for most of the time, that will be the legal status to be enjoyed by the company in all transactions. However, there may arise an occasion during which, for some stated policy reasons, the law will say that we should disregard the corporate veil so that the company is not seen as an entity by certain individuals, certain persons who have done certain acts ostensibly in the name or under the auspices of the company will be held personally liable for their wrongdoing or whatever malfeasance that they may have committed. So there's what we call the lifting the veil or piercing the veil. We will discuss that. Then we will move on to discussion of promoters and pre-incorporation contract. So before a company is formed, certain persons will do a number of things for it to be brought into existence. And certain transactions may also even be entered into in anticipation of the company which is yet to be set up. Sometimes debts are incurred for the company which is yet to come into existence. And when it comes into existence, the company is more or less visited with those debts. So question is that legally maintainable? That a company which is yet to be born, can it incur a debt? Can transactions be done to bind it so that when it comes into existence, it can be pursued as if it had freely agreed to enter into it at the time that it was concluded? Officer, I'm teaching online. We'll talk later. Okay. So the people who help to bring the company into being, as I indicated, the promoters, uh, should they be subjected to higher standards of accountability so that they don't take advantage of the privileged position that they occupy in relation to the company which is yet to come into existence. So we will be discussing duties and liabilities of promoters. And then, as I said, transactions which are made before the company was incorporated, what we call the pre-incorporation contract. Under Ghanaian law, unlike the common law, as a general rule, they are not binding, but they could be binding under strict conditions. So what are those conditions under which pre-incorporation contract will be binding? When and how can it be ratified so that to be fully binding on the company? We will also discuss constitution of the company. Constitution of the company reminds us that the company more or less is like a mini state, okay? Just as in constitutional law, we learned about constitution of the state, that the constitution actually set up the organs of governance, defines powers which the various organs are supposed to exercise, the relationship between them, checks and balance. That is what we learn about constitution in constitutional law. The same idea is mutantes mutandis, or with necessary implication, applicable to constitution of the company. The company too has got various organs. What are the powers and functions of the various organs? What are the relationships between them? So you notice we have like the members in general meeting. Later when we are learning about corporate governance, as being like that being the highest decision-making body. Then we have like the board of directors as the other, before we come to other functionaries. company secretary, auditors, and so on. So all those organs, all those stakeholders, as far as governance of the company is concerned, they are governed by a set of rules, which we call the company's constitution. And the company constitution will also tell us who becomes a member of the company and so on. We used to call the constitution regulations, but with the coming into force of the 2019 Companies Legislation Act 992, our lawmakers have actually abandoned the old language of regulation and have embraced constitution. Interestingly, originally, the what we called constitution and previous regulation was actually known as memoranda of association and articles of association. So there was what we call the duality of company constitution. There were two documents, memoranda of association and then articles of what? Association. But when we adopted our homegrown company legislation in 1963, we abandoned the dual constitutional documents, memorandum of association and article of association, which pertains in England and Wales, and rather adopted a unified constitutional arrangement, which we called the regulations. But in 2019, when we repealed at 179, we have embraced what seems to be the modern trend. If you go to UK, for example, they also talk about the constitution. So we have embraced the constitution and have abandoned the regulation. Now, apart from the constitution, is it possible for shareholders to also make their own agreement, which would enable them to, for example, sidestep certain provisions of the constitution? Then what are the legal effects of the constitution when so approved? You will come to learn that when the constitution of the company is approved, in the eyes of the law, it operates as a contract under seal, between the companies and officers, between the company and members, then among the members, among the direct officers, and so on and so forth. So it operates as a contract under seal. I'm sure somebody will be wondering, what is a contract under seal? Well, I'm referring you to your first year contract law, where we are told that there are two main forms of contract. Simple contract, also known as a parole contract, on one hand, and then a contract under seal, also known as a contract by deed or specialty contract or formal contract on the other hand. And the law is simply that in the case of a simple contract, it need not be in writing. It may be in writing, but it need not be in writing, and it does not require any formalities. And for that matter, for it to be enforceable, there was a need for the person seeking to enforce it to demonstrate that consideration was what was provided. Now, in the case of specialty contract, what do you call the contract under seal? The law is that it must be executed, it must be written, and should have certain formalities, including the seal of the parties. And because of that, there is no requirement for a person seeking to enforce it to demonstrate consideration before they can be what? Enforced. So the constitution of the company is actually treated like that, as a contract under seal. Again, we will also talk about the doctrine of ultra vires, incapacity of companies. Yes, if the company is a corporate entity, a juristic person, artificial legal person, it can enter into transactions like a natural person. That is true. What about where the company on its own has decided to impose certain restrictions on itself in the form of its constitution by saying that it can do X, Y, Z, and it cannot do any other thing. Now, where that is the case, can the company enter into transactions which, according to its constitution, cannot enter into? Or where certain procedures have to be followed, certain approvals should be given before certain things can be done. Can those things be ignored and the company still be held bound by those transactions, which are manifestly contrary or traverse its constitution? So we'll be looking at that. Then we also discuss membership of a company. It says membership of a company. Who may be a member of a company? Who qualifies to be a member of a company? And this is very important, particularly when you're talking about company limited by shares. Oftentimes there's a confusion as whether when a person has been given shares and he has not paid for it fully, he's not a member. Or, so there's a famous case. It's a case which actually came from Kumasi, Adishman Gardens versus Osasibe, which was, no, this issue was really the centerpiece. That where a member has been given shares and he has not fully paid for the shares, does the person continue to be a member of the company? Or because he's not paid fully for the shares, he's not a member? So we discussed that. Then again, if you're a member, there are certain things that you can enjoy from the company. What are those things? So what are the rights, duties, and liabilities which you can enjoy by being a member of a company? We will also start discussing aspects of corporate finance. We look at the share capital and shares. So what is a share? We'll be looking at that. And this is an area where a lot of us have a very poor appreciation. And for that matter, you are not even able to take advantage of it in real life scenarios, to be investing our monies in shares, because you don't even understand what shares are. So we'll discuss that. And then we'll look at the types of shares and then the various classes of shares. How are shares issued? How are shares transferred? And these are very important because oftentimes cases which come before the courts reveal that law students did not take company law serious, because sometimes there are certain matters which notice that if someone had, for example, appreciated certain aspect of company law, the person will have gone about it differently. And that is why I urge you to love company law. Don't say that, as for me, well, I'm not going to become like a corporate lawyer. So what is this about company law? No, that is a big mistake. I can tell you from where I sit that company law manifests itself in so many other areas of the law. Even when we are dealing with criminal law, okay? When we are dealing with criminal law, there's so much company law in it. Recently, you must have heard of like the case involving one Shinaku or something. substantial aspect of the case will turn on company law. Sometimes we're dealing with estate matters, succession, probate matters. Company law will be there. We're dealing with land. You are dealing with land, and there may be like a company law aspect. So company law is not only in the rare context of company law issues, but it can become important indirectly in some other areas of the law. So we need to understand it. So we also look at shareholders' rights and remedies. So what we call the majority rule and minority protection. Yes, where decisions will have to be made, we use the democratic legitimacy principle of what the majority say. But then, for minority, the dissentient, those who do not agree to what the majority prefer, they too should be protected by the law. So what safeguards are there in the law for the minority to withstand the preferences and domination of the majority by sheer reason of their numerical strength? So we will look at that. What used to be known as the rule in force and habitable, but of course, the term rule in force and habitable is just a convenient label, because in substance, that rule has actually been whittled away by so many exceptions that have been recognized. So much so that the exceptions have become more important than what used to be known as the rule in force and habitable itself. So we also discuss what we call the derivative actions and then unfair prejudice remedies. Derivative actions, in other words, from the principle of the separate legal personality of the company, and the company can sue and be sued, where the company has suffered a wrong, it is the company which is supposed to take it up. But we have the directors who are in charge of the company where they are not acting. What can be done? What can be done? So it may be necessary for a member of the company to use the name of the company to sue in matters which the company itself should have taken it up. So under what circumstance can a member of a company, for example, use the name of the company to sue, as it were? Now, where a member is complaining that the affairs of the company are being run in a manner which are in disregard to his proper interests as a member, or are being run in a very unfair, prejudicial way, what remedies are available for such a person? So we'll be discussing that as part of week 8. We will also be discussing first part of company management, company governance, corporate governance. We'll look at board of directors. Board of directors, who is a director? How are directors appointed? Who qualify to be a director? How are they removed? What are their powers and duties? Then the types of directors: the executive directors, non-executive directors, managing director. We'll be discussing all that. Then we'll look at the second component of corporate management. Other officers, such as the company secretary and auditors. We need to understand who is the company secretary. And unlike the old repealed legislation, The new law, Act 992, has actually devoted some space in telling us more about who the company secretary is, the qualification of the company secretary, his appointment and removal processes, and so on. All those have been set out in the law, and we need to know it. And auditors, I'm sure from what we have witnessed in the banking sector crisis, you appreciate how auditors are important, because auditors are those who are supposed to go over the books, prepare for the company, and tell us whether the books have been kept properly regarding accurate recording of transactions, income flows, and expenditure, outgoings, and so on. Have they properly been kept according to standardized principle? If the answer is no, then something might have gone wrong and the red flag will have to be raised and directors will need to intervene. So, who qualify as an auditor? How are auditors appointed? What are the duties of the auditor? So, we'll be discussing all that. And hopefully, we're able to have another aspect of corporate governance generally. So, the Bank of Ghana, for example, has been active in trying to provide some sort of like a blueprint of what constitute good corporate governance code. So the Bank of Ghana issued a directive following the banking collapse or crisis, as it were. So we're looking at principles of good corporate governance, and we look at the regulatory framework, especially the one provided by the Securities and Exchange Commission and also the Bank of Ghana, which I just alluded to. And also look at the Registrar of Companies. What does the Registrar of Companies do as far as corporate governance is concerned in the country? And we have our revisions and seminar presentations. So those are the things that we'll be discussing in the first semester. So in terms of assessment regime, we have like a portfolio of activities, class participation and quizzes that should give you 10%. Group presentation should give you 10%. I will recalibrate the group presentation depending upon the number that we do and see if I'll move some marks around. And then the May semester exams to 20%. So all giving you 40% of the continuous assessment according to university rules. And then the end of semester exam will give you 60%. So that will be the picture of how company law will be assessed in the first semester. Because it is one course, I will have gone ahead to introduce the second part of the course, but I will skip it. Then when we get to the second semester, then we will do that. But there's one point I want to bring out that, and I want you to look at what I put in the red, that despite the above list of topics, as much as possible, teaching will be a linear textual analysis, a discussion of Companies Act 2019 and related legislation. So I'm saying that, yes, I've told you like the topics, but because I want us to engage the law itself, there are times that I will just open the law on the screen like this, and then I will just explain the law. And if there are supporting authorities or cases, we will cite them and then look at them as well. So, and again, if there are academic articles which are relevant to any of the things that we are learning, I will also make them available to you, and you have to read to supplement and consolidate your understanding of what we are doing. Yes, so I will end the introduction of the first semester course here. And tomorrow is Friday. So I know Friday you go for your lectures. So you'll not be able to meet here, but Saturday,